Lorenz, would the defense like to call any witnesses?
The defense rests.
With that, we are going to proceed with the reading of the final jury instructions. My bailiff will provide you with a copy, just as we did with the reading of the preliminary jury instructions. You may either follow along or sit and listen, whichever is your preference. I am going to be reading at a relatively quick rate. It may be that I do not finish by 4:30. I beg your indulgence. It may be 4:40 before I am done. But with that, we will be done for the week, and then we will be coming back on Monday to do our closing arguments. So reading these jury instructions now allows us to use up the time that we have and then begin on Monday with closings. Does everyone have a copy of the jury instructions? Beginning on what is labeled as page 1. Your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. The state has charged the defendant with certain crimes. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charges beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of the charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you think that there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. You are to determine what the facts in the case are from the evidence produced in court. If an objection to a question was sustained, you must disregard the question, and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. In their opening statements and closing arguments, the lawyers have talked to you about the law and the evidence. What the lawyers said is not evidence, but it may help you to understand the law and the evidence. The lawyers are permitted to stipulate that certain facts exist. This means that both sides agree those facts do exist and are part of the evidence. You are to treat a stipulation as any other evidence. You are free to accept it or reject it, in whole or in part, just as any other evidence. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits might have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence, regardless of whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before the trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that a witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. A witness is qualified as an expert by education or experience, may state opinions on matters in that witness's field of expertise, and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all of the other evidence in the case. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant acting with the advice of an attorney. You must not let this choice affect your deliberations in any way. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all of the circumstances. You have heard evidence that certain witnesses have previously been convicted of a criminal offense. You may consider this evidence only as it may affect the believability of those witnesses. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Neither side is required to call as witnesses all persons who may have been present at an event disclosed by the evidence, or who may appear to have some knowledge of these events, or to produce all documents or evidence suggested by the evidence. In determining whether the state has proved the defendant guilty beyond a reasonable doubt, you may consider any evidence of the defendant's running away, hiding, or concealing evidence, together with all the other evidence in the case. You may also consider the defendant's reasons for running away, hiding, or concealing evidence. Running away, hiding, or concealing evidence after a crime has been committed does not by itself prove guilt. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and who did not participate in the crime. The state has the burden of proving that the defendant was present at the time and place the alleged crime was committed. If you have a reasonable doubt whether the defendant was present at the time and place the alleged crime was committed, you must find the defendant not guilty. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. It is not a defense to any criminal act if the criminal act was committed due to temporary intoxication resulting from the voluntary ingestion, consumption, inhalation, or injection of alcohol, illegal substances, or psychoactive substances, or abuse of prescribed medications. The charged offenses. The defendant is charged with 8 separate counts. 1 count of attempt to commit first-degree murder, count 1. 3 counts of aggravated assault, counts 2, 3, and 4. 1 count of drive-by shooting, count 5. And 3 counts of threatening or intimidating, counts 6, 7, and 8. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proved beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. The crime of attempt to commit first-degree murder requires proof that the defendant, 1, intentionally engaged in conduct that would have been the crime of first-degree murder if the circumstances relating to the crime were as the defendant believed them to be, or 2, intentionally committed any act that was a step in a course of conduct that the defendant planned would end or believed would end in the commission of the crime of first-degree murder. The crime of first-degree premeditated murder requires proof that the defendant, 1, caused the death of another person, and 2, intended or knew that he would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew he would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. The crime of aggravated assault requires proof of the following. 1, the defendant committed an assault, i.e., intentionally put another person in reasonable apprehension of imminent physical injury. And 2, the assault was aggravated by the fact that the defendant knew or had reason to know that the person assaulted was a peace officer engaged in official duties. The crime of drive-by shooting requires proof of the following. 1, the defendant intentionally discharged a weapon from a motor vehicle, and 2, the discharge was at a person, another occupied motor vehicle, or an occupied structure. The crime of threatening or intimidating requires proof of the following. The defendant threatened or intimidated by word or conduct to either A, cause physical injury to another person, or B, to cause serious damage to the property of another person, and 2, the defendant was a criminal street gang member. The defendant has pled not guilty to these charges. The state must prove each element of each charged crime beyond a reasonable doubt. Definitions. Criminal street gang means an ongoing formal or informal association of persons in which members or associates, individually or collectively, engage in the commission, attempted commission, facilitation or solicitation of any felony act, and that has at least one individual who is a criminal street gang member. Criminal street gang member means an individual to whom at least 2 of the following 7 criteria that indicate criminal street gang membership apply. A, self-proclamation. B, witness testimony or official statement. C, written or electronic correspondence. D, paraphernalia or photographs. E, tattoos. F, clothing or colors. G, any other indicia of street gang membership. Deadly weapon means anything that is designed for lethal use. The term includes a firearm. Firearm means any loaded or unloaded handgun, pistol, revolver, rifle, shotgun, or other weapon that will expel, is designed to expel, or may be readily converted to expel a projectile by the action of an explosive. Firearm does not include a firearm in permanently inoperable condition. Peace officer means any person vested by law with the duty to maintain public order and make arrests. Intentionally, or with intent to, means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knew or knowingly means that a person acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a person must have known the conduct is forbidden by law. If the state is required to prove that a person acted knowingly, that requirement is satisfied if the state proves that the person acted intentionally. The case will soon be submitted to you for decision. This will occur on Monday. When you go to the jury room, you will choose a foreperson on Monday. The role of the foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1. Make sure every member of the jury is present during all discussions and deliberations. 2. Make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussion should be open and free so that every juror may participate. 3. All jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4. All members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5. If you reach a verdict, fill out the verdict forms and then sign the forms on behalf of the jury. 6. If the jury reaches a verdict, the foreperson will inform the bailiff. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict forms, as well as any question forms that may have been used. 7. When you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond, yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. On Monday, you will hear closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule on Monday. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the bailiff. You are to discuss the case and deliberate only when all jurors are together in a jury room. You are not to discuss the case with each other or anyone else during the breaks or recesses. The admonition I have given to you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the written jury instructions and the verdict forms. It may be helpful for you to discuss the instructions and verdict forms to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand, numerically or otherwise, until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, BlackBerry or computer, the internet or any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, MySpace, LinkedIn, YouTube, or Twitter, to communicate to anyone any information about this case, or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 of you agree on a verdict, only the foreperson need sign the verdict form on the line marked jury foreperson. You will be given 8 forms of verdict. The verdict forms read as follows, and there is no significance to the order in which the options of guilty and not guilty are listed on the verdict forms. Please note these are sample verdict forms. Official verdict forms will be given to you by the bailiff in the jury room on Monday. Count 1, attempt to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do unanimously find the defendant as to count 1, attempt to commit first-degree murder, not guilty, guilty, with the four-person signature. Counts 2, 3, and 4, aggravated assault. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do unanimously find the defendant as to count 2, aggravated assault, to wit, James Casey. Count 3, aggravated assault, to wit, Reynaldo Cruz. Count 4, aggravated assault, to wit, Mike Alfano. Checkbox not guilty, checkbox guilty. Juror four-person signature block. Count 5, drive-by shooting. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do unanimously find the defendant as to count 5, drive-by shooting. Checkbox not guilty, checkbox guilty. Four-person signature block. Counts 6, 7, and 8, threatening or intimidating. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do unanimously find the defendant as to count 6, threatening or intimidating, to wit, James Casey. Count 7, threatening or intimidating, to wit, Reynaldo Cruz. Count 8, threatening or intimidating, to wit, Mike Alfano. Checkbox not guilty, checkbox guilty. Signature block for the jury four-person. So at this time, we are going to adjourn for the week. Remember, the admonition applies. Also, remember, I would advise you not to be watching the news because it is entirely possible that there could be media coverage of this case. What the news media chooses to cover is up to them, but we want to do what we can to minimize any potential exposure to any coverage of this case. You are not to discuss this case among yourselves. You are not to discuss this case with any third parties. The case has not yet been turned over to you for your deliberation. We will do that on Monday after the closing arguments. Please make sure to be here on time on Monday. We will get started at 10:30. Thank you very much for your attention this week. Have a wonderful weekend, and we'll see you on Monday.
All rise for the hearing.
Please be seated. Counsel, is there anything we need to address before we adjourn for the weekend?
No, thank you.
Oh, Your Honor, thank you.
Thank you, everyone. We'll see you on here on Monday.
Judge.